Chapter 11. Corporate Customer Onboarding and KYC Legal Entities. Group Structures, Beneficial Ownership, and Compliance Realities. Before a bank can extend credit to a corporate borrower, it must complete a rigorous onboarding and know your customer or KYC process. This process is not merely a formality. It is a critical risk management and regulatory compliance function that establishes the borrower's identity, assesses their legitimacy, and ensures the bank is not facilitating money laundering, terrorist financing, or other illicit activities. Section 1. Why corporate KYC is complex. Unlike retail customers, corporate entities present unique challenges for KYC. A corporation is not a natural person. It is a legal construct that can have complex ownership structures, multiple layers of subsidiaries, and beneficial owners hidden behind nominee shareholders or trusts. Understanding the true ownership and control of a corporate borrower is essential for several reasons. First, regulatory compliance. Anti-money laundering and counter-terrorist financing regulations require banks to identify and verify the beneficial owners of corporate clients. Second, credit risk assessment. The financial strength and reputation of the ultimate beneficial owners can significantly impact the borrower's creditworthiness. Third, sanctions screening. Banks must ensure they are not doing business with individuals or entities subject to economic sanctions. Section 2. Legal entity identification. The first step in corporate onboarding is to identify the legal entity itself. This involves collecting and verifying documents such as the Certificate of Incorporation, Business Registration Certificate, Articles of Association or Bylaws, and Tax Identification Number. The bank must also determine the entity's legal form. Is it a corporation, partnership, limited liability company, or trust? Each legal form has different implications for liability, governance, and risk. Section 3. Group structures and related parties. Many corporate borrowers are part of larger corporate groups with parent companies, subsidiaries, and affiliates. Understanding the group structure is critical because related entities often share common risks and dependencies. The bank must map the entire group structure, identifying parent companies, subsidiaries, sister companies, and joint ventures. It must also identify related parties, such as key shareholders, directors, and entities with common ownership or control. This information is essential for limit management, as discussed in Chapter 10. The bank must aggregate exposures across all related entities to avoid concentration risk. Section 4. Beneficial ownership identification. Beneficial ownership refers to the natural persons who ultimately own or control the corporate entity. Regulatory requirements typically mandate that banks identify any individual who owns or controls more than 25% of the entity, either directly or indirectly. Identifying beneficial owners can be challenging, especially when ownership is held through multiple layers of holding companies, trusts, or nominee arrangements. The bank must trace ownership through each layer until it reaches natural persons. The loan management system must support beneficial ownership tracking, allowing the bank to document the ownership chain, store supporting evidence, and flag any changes in ownership that may require re-verification. Section 5. Sanctions and PEP screening. Once the corporate entity and its beneficial owners have been identified, the bank must screen them against sanctions lists and politically exposed persons or PEP databases. Sanctions lists include individuals and entities subject to economic restrictions imposed by governments or international bodies. Doing business with sanctioned parties can result in severe penalties, including fines and loss of banking licenses. Politically exposed persons are individuals who hold or have held prominent public positions, such as heads of state, government ministers, or senior officials. Transactions involving PEPs carry higher money laundering risks and require enhanced due diligence. The screening process must be automated and performed not only at onboarding but also on an ongoing basis, as sanctions lists and PEP databases are updated regularly. Section 6. Document collection and verification. Corporate onboarding requires the collection and verification of numerous documents, including financial statements, proof of business address, board resolutions authorizing the credit facility, and identification documents for authorized signatories. The bank must verify the authenticity of these documents, often by obtaining certified copies or using third-party verification services. The loan management system must provide a secure repository for storing these documents and maintaining an audit trail of all verification activities. Section 7. Ongoing monitoring and periodic review. KYC is not a one-time event. It is an ongoing process. The bank must monitor the borrower's activities for unusual or suspicious transactions and conduct periodic reviews to ensure that the KYC information remains current. Regulatory requirements typically mandate that corporate KYC be reviewed at least annually or more frequently for high-risk clients. The system must generate alerts when reviews are due and provide workflows for updating information and rescreening against sanctions and PEP lists. This concludes Chapter 11, Corporate Customer Onboarding and KYC Legal Entities, Group Structures, Beneficial Ownership, and Compliance Realities.